Welcome to the law offices of Chris M. Ingram's Immigration News Roundup podcast. Today, we are reviewing the main U.S. immigration news events that have occurred over the last week. We would like to thank the staff at the law offices of Chris M. Ingram, who have worked very hard in researching and preparing the material for this podcast from a wide variety of news sources from both sides of the aisle so that you get a balanced view. Our coverage is designed to be nonpartisan. This past week, from June 9th to the 15th, 2025, wow, the landscape of U.S. immigration saw some truly intense activity. The material prepared by the legal team for this deep dive points to a period marked by, well, a fierce focus on immigration enforcement, significant legal battles unfolding, widespread protests across the country, and notable policy shifts from the administration. Our mission today is to unpack these key events that the legal team has meticulously researched, helping you understand not just what happened, but digging into the implications and why these developments matter in the broader context of U.S. immigration policy and federal power dynamics.
That's right. The research prepared by the legal team gives us a clear, if somewhat volatile, picture of a week where tensions were really running high. You had the courts, the streets, government policy, all actively engaged in this ongoing debate around immigration. It's a complex puzzle, for sure, and the material really helps us piece together the most critical developments.
Absolutely. And one concept that seems, well, absolutely central to understanding many of the week's headlines based on the legal team's findings is this idea of sanctuary cities. For someone maybe following this topic but wanting a solid grounding, how does the legal team's material define what these are?
Well, the legal team's definition, it aligns with the common understanding, but, with some important nuance. Sanctuary cities, or maybe more broadly, sanctuary jurisdictions, these are state or local governmental entities, so cities, counties, even whole states. And they've chosen to adopt policies designed to limit their cooperation with federal immigration enforcement agencies, specifically ICE, Immigration and Customs Enforcement.
Okay. ICE. So it's about setting boundaries on that specific interaction with federal immigration agents.
Precisely. The material highlights that there's no single, uniform legal definition across the board. You won't find one statute defining it everywhere. But the core function is consistent. They establish policies that create a degree of separation, you could say, between local law enforcement and federal immigration enforcement.
And what do those specific policies typically involve? What does limiting cooperation look like in practice, according to the legal team's research?
The legal team's research outlines some key examples. A primary one is the refusal to honor what are called ICE detainers. These are basically requests from ICE asking local jails or police to hold individuals beyond their scheduled release date. Hold them just so ICE can come pick them up for deportation proceedings.
Oh, okay.
Sanctuary policies often require a judicial warrant before they'll honor such requests. They argue that an administrative detainer from ICE itself isn't sufficient legal basis for that extended detention under state law.
Got it. Needs a judge's sign-off.
Right. Another common policy is prohibiting local police officers from proactively asking about a person's immigration status during, say, routine interactions like a traffic stop. And importantly, these jurisdictions often aim to ensure that all residents, regardless of their immigration status, feel safe accessing essential public services.
Like schools or hospitals.
Exactly. Schools, hospitals, even reporting crimes. The idea is they shouldn't fear that doing so will trigger their deportation.
That distinction about not honoring detainers without a judicial warrant seems pretty significant. It's not saying they won't cooperate at all, but they require a higher legal threshold.
Exactly. The legal team's material really underscores that. It's not about shielding individuals from all law enforcement or, preventing cooperation on serious criminal matters. Not at all. It's about limiting entanglement in the civil process of immigration enforcement, particularly when it lacks that judicial directive. The stated aim, as the research notes, is multifaceted. Yes, protect undocumented immigrants from deportation, but also to build trust within these communities.
Build trust. How so?
Well, the thinking is, if immigrants fear deportation every time they interact with any official, they'll be less likely to report crimes they witness or are victims of, right? Or to engage with local authorities generally. And that, proponents argue, makes the entire community less safe. So sanctuary policies are seen by their supporters as a way to foster that trust and actually enhance public safety overall.
That makes a lot of sense from a community perspective. Where did this movement even start? The legal team's research mentions a historical context, right? It didn't just appear overnight.
Oh, definitely not. It certainly didn't. The legal team's material traces the origins of the sanctuary movement back quite a ways, actually to the 1980s. This was a period when you had significant numbers of asylum seekers arriving, mainly from Central American countries torn apart by civil wars.
Okay, fleeing violence.
Exactly, fleeing violence, persecution. But the U.S. government under the Reagan administration at the time was often denying their asylum claims. So in response, a movement emerged where churches, primarily, began offering physical refuge and protection to these individuals. They declared themselves sanctuaries. It was very grassroots, humanitarian, often faith-based, a response to what they saw as an unjust government policy.
So it started outside of formal government structures then. When did it become actual city or state policy?
The research shows that shift towards formalized government policy started picking up by the 1990s. This was partly a reaction to increased federal efforts to apprehend and deport immigrants, federal crackdowns. The passage of significant federal laws like the Illegal Immigration Reform and Immigrant Responsibility Act of 1996 IRA that really expanded grounds for deportation and enforcement tools. That spurred some local jurisdictions to proactively set up policies offering a layer of protection to their immigrant residents. And the legal team's research points to California as a prime example of this formalization process, especially at the state level.
California often comes up in discussions about sanctuary policies, doesn't it? What specific details did the legal team's material provide about California?
Yeah, California's evolution is particularly relevant here. The legal team's material highlights Senate Bill 54, which was enacted back in 2017, signed by then-Governor Jerry Brown. It's often called the California Values Act, and it significantly expanded and sort of codified the state's status as a sanctuary state.
How did it do that?
Well, SB 54 placed pretty broad restrictions on state and local law enforcement agencies. It limited their ability to use their resources or personnel to help federal immigration enforcement. However, and the legal team emphasizes this as a critical point, the law does still permit cooperation with federal authorities for individuals convicted of certain serious violent felonies. So it's not like an absolute shield for everyone, but it creates significant barriers to just routine cooperation on civil immigration matters.
Got it. And Los Angeles, specifically, seems to be a real flashpoint in the current news cycle. What does the legal team's material tell us about LA's situation?
LA is definitely highlighted in the legal team's material as a major focal point, and you can see why. The research points out the sheer scale of the immigrant community there. Roughly 1 in 3 residents in LA are immigrants, and there are an estimated 800,000 undocumented individuals living just in LA County alone. Huge numbers.
Wow, 800,000.
Yeah. So this large, deeply integrated population means that LA's commitment to its sanctuary policies has a massive real-world impact. The city leadership, as presented in the research, often emphasizes the economic and cultural contributions of immigrants. They see policies that support integration rather than, fear as essential for the city's well-being. And this commitment, this visibility, is exactly what makes LA such a key target for administrations focused on increasing deportations.
That brings us right to the core tension we saw playing out this past week. Why is the Trump administration, according to the legal team's findings, specifically targeting these sanctuary jurisdictions with such intensity?
Well, from the perspective of the administration, as it's laid out in the legal team's material, sanctuary jurisdictions are seen as significant obstacles, even as actively undermining federal law. They're often characterized, quite harshly, as havens for illegal alien criminals. That phrasing implies they deliberately shield dangerous individuals from deportation.
And the administration has clear enforcement goals, right?
Yes. The administration's stated goal is to deport millions of individuals and conduct a really high volume of daily arrests. The number often cited is a target of 3,000 migrants daily. And they see sanctuary policies as directly obstructing these efforts by limiting that local assistance ICE often relies on.
And President Trump's rhetoric on this has been consistently strong over the years.
Absolutely. The legal team's notes reflect President Trump's consistent and very vocal opposition to sanctuary cities. He has repeatedly argued that they endanger American citizens by preventing the removal of individuals who he claims are dangerous or criminal. His public statements often frame this issue as a matter of national security and public safety that's being, thwarted by liberal state and local governments.
Given that view, what specific tactics does the administration employ to target these jurisdictions based on the legal team's research?
The legal team's material details a kind of multi-pronged approach. It involves directly targeting Democratic-led jurisdictions with large immigrant populations, think LA, New York, with aggressive enforcement actions. This includes deploying significant federal resources, like the National Guard, which we'll definitely talk more about, a highly controversial move. It includes conducting high-profile and aggressive ICE raids, particularly in workplaces and communities, and launching legal challenges directly against state and local policies that limit cooperation.
Like the New York lawsuit we'll get to.
Exactly. The legal team's notes also mention specific tactics like Operation Guardian Angel. This reportedly involves using federal felony warrants as a way to sort of bypass local sanctuary laws that might otherwise require judicial warrants for civil immigration arrests. The stated aim of all these tactics, from the administration's perspective, is basically to dismantle local resistance and assert federal authority.
It's clearly a strategy of direct confrontation. Now, the legal team's material is careful to present the differing perspectives on this intense targeting. We have California leaders defending sanctuary policies and Republican senators advocating for stricter enforcement. Let's make sure we capture the essence of both sides as presented in their research, maintaining that strict impartiality.
That's absolutely key. The legal team's research provides viewpoints that are fundamentally opposed here. On one side, you have California leaders. Los Angeles Mayor Karen Bass, for instance. She's been a very vocal critic of the administration's tactics. In a post on X, the platform formerly known as Twitter, from June 15th, she called these federal attacks a body blow to LA's economy. She highlighted industries like restaurants, construction, fashion, schools, all rely heavily on immigrant labor and contributions. She used the powerful phrase, "Save the economy, stop the raids."
And she spoke at a vigil, too.
Yes, the legal team also noted her comments at a vigil on Juneteenth. There she argued that conducting raids on places like Home Depots and tearing families apart with armored caravans, as she put it. She said that's not about keeping people safe. It's about causing fear and panic within communities. Her quote was pretty direct. When you raid Home Depots and workplaces, you're not trying to keep anyone safe. You're trying to cause fear and panic.
Powerful words. And Governor Newsom's perspective from the research.
Governor Gavin Newsom has really echoed Mayor Bass's concerns. The legal team's material noted his comments on a daily podcast on June 12th. He acknowledged the need to remove criminals, get rid of the criminals, I have no problem with that, but insisted it be done civilly and responsibly. He drew a sharp contrast between targeted criminal enforcement and these broad raids that impact families and communities. The research also included his post on X from June 8th, where he stated, "The federal government is sowing chaos so they can have an excuse to escalate. That is not the way any civilized country behaves."
So their argument is strongly tied to the practical consequences, the method of enforcement, and the impact on the community and economy.
Exactly. The combined perspective from these California leaders, as presented in the legal team's analysis, argues that the administration's aggressive tactics are disruptive, harmful, fuel civil unrest, and seem politically motivated rather than genuinely focused on safety.
Okay, now let's look at the other side. What about the Republican senator's perspective, as provided by the legal team?
The legal team's material presents a clear and, frankly, unified counterpoint from several Republican senators, including James Lankford, Ted Cruz, and Tom Cotton. Their core argument really boils down to a principle. Individuals who are in the U.S. without legal status and who violate laws, and in their view, simply being here without authorization is the primary law violation. They forfeit any right to remain and should be subject to deportation. Full stop.
And their specific comments reflect that.
They do. The legal team's notes include comments from Senator James Lankford on NBC's Meet the Press on June 8th. He framed President Trump's actions as attempts to de-escalate all the tensions that are there, suggesting the federal response is actually necessary because of existing problems. Senator Ted Cruz, speaking on Fox News on Juneteenth, was quoted stating very bluntly, "If you're here illegally, you've already broken the law. We can't reward that with sanctuary." That really encapsulates the view that sanctuary policies enable lawbreaking. And Senator Tom Cotton, in a statement on June 11th, directly criticized sanctuary policies, saying they protect criminals, not communities, and asserted that the Trump administration is right to crack down.
So their view is that enforcement is paramount for law, order, and security.
That's the essence of it, as synthesized by the legal team. They see these federal enforcement actions as essential for upholding the rule of law, securing the border by deterring illegal immigration, and enhancing national security by removing individuals they view as a threat. State and local resistance, from this perspective, is just an impediment to necessary federal functions.
Those are indeed fundamentally different viewpoints presented by the legal team. The material also connects these aggressive tactics directly to the widespread unrest and protests we saw this past week. Why does the research suggest this is causing such a strong reaction?
The legal team's analysis indicates a pretty direct causal link. The material suggests that the nature of the administration's tactics, especially the large-scale, often very public raids, the, frankly, unprecedented deployment of military assets like the National Guard in a civilian setting like LA, and the inflammatory rhetoric used to describe immigrants and sanctuary jurisdictions, all of this is perceived by many people as an attack on their communities. This perception directly ignites unrest. The material highlights that protesters are often defending neighbors, family members, people they see as hardworking individuals just trying to build a better life.
So it disrupts lives directly.
Absolutely. The forceful nature of the enforcement actions disrupts daily life, separates families, creates this pervasive climate of fear. Furthermore, the research notes that the administration's often harsh characterization of the protesters themselves, for example, reports mention them being labeled as violent insurrectionists that further escalates tensions. So you get this cycle. Aggressive enforcement leads to protest, which is then met with strong condemnation and potentially more force from the federal government, which then fuels further unrest and deepens the divide. It's like a feedback loop of action, reaction, and counter-reaction.
It paints a picture of incredibly high stakes and a really volatile situation on the ground. Let's now turn to some of the specific major headlines and legal developments that the legal team focused on in their report for the week of June 9th to 15th. The first big one involves a direct lawsuit targeting New York State. Tell us about that.
Right. This was a significant legal development. It occurred on June 12th, 2025. The legal team's report captured it with the headline, "Trump administration unleashes legal fury on New York's courthouse arrest ban." The summary they provided is that the federal government filed a major lawsuit against New York State, specifically challenging a state law that bans ICE arrests inside or near courthouses unless IC has a judicial warrant. The administration claims, according to the material, that this state law directly defies federal authority and is a significant obstacle to their deportation goals.
A federal lawsuit against a state over its immigration-related law, that's a pretty direct confrontation, isn't it?
Yeah.
What are the specific details of this lawsuit presented in the legal team's notes?
The legal team's material specifies that the lawsuit was filed in federal court up in Albany, New York on June 12th. It directly targets New York's state law, which was actually enacted back in 2020. And this law explicitly prohibits federal immigration agents, including ICE, from making arrests in or near courthouses unless they are acting pursuant to a warrant issued by a criminal court judge or a magistrate judge. Basically, it requires judicial authorization, not just an administrative warrant or detainer from ICE itself.
Okay. And what is the administration's core legal argument against this state law? Why do they say New York can't do this?
Their primary legal argument, as outlined in the legal team's analysis, really centers on the Constitution's Supremacy Clause. You know, the clause that says federal laws made pursuant to the Constitution are the supreme law of the land, overriding conflicting state laws. The administration argues that New York's law interferes with and obstructs ICE's congressionally mandated mission to enforce federal immigration laws. ICE specifically argues, according to the material, that courthouses are actually ideal, even necessary, locations to apprehend non-citizens, especially those with criminal histories or final orders of removal.
Why ideal?
Because they're controlled environments. Individuals can often be located there with a predictable schedule. They argue it minimizes risks compared to, say, street arrests. They contend that the New York law hinders their ability to conduct operations efficiently, including hitting that daily target of detaining 3,000 migrants.
What are some of the key developments in this case so far, according to the legal team's report? Has anything happened yet?
The legal team notes several points. First, this lawsuit is seen as a really significant escalation in the administration's legal strategy targeting sanctuary policies. It's a direct confrontation with one of the most prominent sanctuary states. As of the time of the report, no major ruling had been issued yet. It's still early days. But the material highlights that this case has the potential to work its way up the federal court system, possibly even reaching the Supreme Court. Even the constitutional questions involve federal supremacy versus state autonomy. The legal team also points out that ICE continues to assert that judicial warrants are not, in their view, legally required for civil immigration arrests under federal law. That's the very point of contention with the New York statute.
Why did New York pass this law back in 2020 in the first place? What was the driver for it?
The background provided by the legal team explains that New York's law was a direct response to a noticeable increase in ICE on courthouse arrests during the early years of the Trump administration. Immigrant advocates and state officials argued these arrests were basically terrifying immigrants, deterring them from attending court proceedings for totally non-immigration-related matters, things like domestic violence cases, child custody hearings, even just traffic violations.
Ah, so it impacted the state's own court system.
Exactly. This fear meant victims and witnesses might not show up, or individuals couldn't resolve their legal issues. It undermined the state's own justice system and public safety efforts. The law was intended to ensure that immigrants felt safe enough to access New York's courts without the constant fear of being grabbed by federal agents simply for showing up. It reflects that broader pushback against federal immigration tactics that states felt were negatively impacting their own functions and residents.
Looking ahead, what are the potential implications of this lawsuit? According to the legal team's analysis, what could happen?
The legal team's material outlines some significant potential consequences. For immigrants, obviously, if the administration wins, it could lead to a reinstatement of routine courthouse arrests. That creates a major deterrent to accessing justice, potentially undermining their due process rights in other legal matters. For policymakers, a ruling against New York could set a precedent that significantly weakens the ability of states and localities to enact policies pushing back against federal immigration enforcement. It could shift the balance of power further towards the feds under the Supremacy Clause. And for communities, particularly in places like New York City with huge immigrant populations, the increased enforcement presence and fear could spike tensions, potentially fueling more civil unrest and protests. It adds another layer of conflict.
The legal team gathered perspectives and quotes on this lawsuit. What do they include? Who's saying what?
The legal team's material includes several key voices. An unnamed ICE official was quoted expressing the administration's frustration, stating, "These laws pose intolerable obstacles to federal immigration enforcement." Pretty blunt. Offering the opposing view, New York State Senator Brad Horman-Segal, who actually sponsored the state law, was quoted on CNN's The Lead with Jake Tapper on June 13th. He said, "This is about ensuring immigrants can access our courts without fear. Trump's tactics are pure intimidation." And providing some legal analysis, Laura Coates, CNN chief legal analyst, also on June 13th, offered perspective on the legal complexities. This case could redefine federal-state dynamics. New York's public safety argument is strong, but the Supremacy Clause looms large, highlighting that core legal tension.
And the pundit reactions the legal team noted. How is this being framed by different media commentators?
The legal team's report includes pundit reactions from, let's say, predictable corners. Bret Baier on Fox News, in notes from June 13th, framed the New York law as actively handcuffing ICE. He argued it prevents federal agents from keeping Americans safe by apprehending individuals who should be deported. He asserted federal authority must prevail to secure our borders and prevent illegal immigrants from being shielded by state policies that undermine national security. Baier characterized the lawsuit as a critical step toward restoring law and order.
Okay, that's one perspective. And the contrasting view.
Chris Hayes on MSNBC, according to the legal team's report from June 12th, presented the lawsuit very differently as a direct assault on states' rights and immigrant communities. He argued the administration's real motivation is not about law enforcement. It's about fear-mongering and targeting vulnerable people to score political points. Hayes framed the lawsuit as part of a broader strategy to intimidate and dehumanize immigrants, claiming it's tearing apart the fabric of our communities by making people afraid of the justice system. His perspective, as reported, views it as a politically charged action undermining state autonomy and harming immigrants.
The legal team's notes also mentioned related stories around this particular lawsuit, putting it in context.
Yes, the material connects this legal challenge to the broader context of the administration's enforcement push. It mentions related actions like the visa suspensions, impacting certain countries, and those controversial National Guard deployments. It also notes that this is likely not an isolated incident, with similar legal challenges against sanctuary policies potentially brewing in other states like California and Massachusetts, suggests a coordinated legal strategy.
Okay, let's move on to the second major event, highlighted in the legal team's report, a truly stunning and controversial court ruling involving Venezuelan individuals who had already been deported.
Yeah, this event unfolded on June 10th, 2025, and it's quite remarkable and frankly concerning to many observers. The headline from the legal team's summary captures the shock. Court stuns nation by pausing due process for deported Venezuelans. The summary states that a U.S. appeals court issued a ruling that essentially froze a lower court judge's order. That order would have granted nearly 140 Venezuelans who were deported to El Salvador's notorious CECOT prison the right to actually challenge their expulsions in a U.S. court. This appeals court decision, according to the legal team's material, ignited outrage among advocates and legal observers.
That sounds incredibly concerning, pausing due process rights for people already deported to a place like that.
Yeah.
What are the specifics here? What did the administration do?
The legal team's details indicate that back in March 2025, the Trump administration deported this group of approximately 140 Venezuelans. What makes this particularly unusual and legally controversial is that the administration reportedly used a very old, rarely invoked law, the 1798 Alien Enemies Act, as the basis for these deportations. And adding another layer, these individuals were not deported back to Venezuela, but to El Salvador, specifically to the Terrorism Confinement Center, CECOT. That's that massive high-security prison built by the Bukele government, known for extremely harsh conditions.
Why El Salvador?
Unclear.
Why the 1798 law?
The administration alleged these individuals had ties to gangs, specifically mentioning the Venezuelan criminal organization Trended Aragua. They use this allegation to justify the deportation under the Alien Enemies Act's provisions regarding perceived threats during an emergency. Now, on June 4th, U.S. District Judge James Boasberg in Washington, D.C., had issued an order ruling that these individuals were still entitled to due process, basically a meaningful chance to challenge their removal and the allegations against them, even though they'd already been deported. The appeals court's action on June 10th was to issue a pause or a stay on Judge Boasberg's order. This temporarily halts the requirement for the U.S. government to provide them due process. It leaves the deported Venezuelans detained in El Salvador while the legal fight continues here.
Using a law for 1798 passed during a quasi-war with France to deport people in 2025 and sending them to a prison in El Salvador. That's highly unusual, to say the least.
It is, and that's a major point of controversy highlighted in the legal team's material and by commentators. The 1798 Alien Enemies Act allows for expedited removal of individuals deemed alien enemies if the U.S. is at war or facing a declared national emergency. Critics argue, as noted in the legal team's research, that the Trump administration is misapplying this law way outside its intended context, using it as a tool for summary deportations without the standard legal protections immigrants typically get. Deporting them to El Salvador likely reflects some diplomatic agreement between the U.S. and the Bukele government, and perhaps difficulties deporting directly to Venezuela. The material indicates this case is part of a broader legal battle over the administration's use of executive authority and older statutes to achieve rapid, large-scale deportations, bypassing standard immigration court procedures.
What are the key implications of this appeals court ruling based on the legal team's analysis?
The legal team's material outlines some really serious implications. For the nearly 140 immigrants directly involved, well, the appeals court's pause means their access to U.S. due process is delayed indefinitely. It leaves them in prolonged detention in El Salvador's CECOT prison under conditions widely reported as extremely harsh. For policymakers in the legal system, if this use of the Alien Enemies Act and the subsequent ruling holding up due process are ultimately upheld, it could set a dangerous precedent. It could potentially legitimize using obscure wartime-era laws for routine immigration enforcement, expanding executive power to deport people without standard court proceedings. For Venezuelan communities here in the U.S., the material suggests this action and ruling fuels significant fear of further arbitrary deportations, maybe targeting perceived dissidents or those with tenuous connections to criminal groups. It breeds distrust and anxiety.
The legal team included various quotes and perspectives on this controversial ruling. What did they find?
They did. An administration lawyer was quoted by Reuters on June 10th defending the action, stating simply, "The Alien Enemies Act grants clear authority for swift action against threats," framing it as a necessary security measure. Offering a starkly different viewpoint, Gerline Joseph, executive director of the Haitian Bridge Alliance, spoke on Democracy Now! On June 10th. She criticized the action as rooted in bias. "This is not about security, it's about anti-brown racism. These deportations are inhumane," framing it as discriminatory and cruel. And commenting on the legal novelty, Pamela Brown on CNN on June 11th concisely posed the central legal question, a 1798 law in 2025. The courts must decide if this is legal overreach.
And the pundit reactions the legal team noted on this ruling. How did the commentators frame it?
On Fox News, Sean Hannity, according to the legal team's June 10th notes, strongly supported the administration's move. He asserted the deportees were gang members, not innocent refugees, justifying their removal based on those alleged criminal ties. He argued the administration is protecting Americans by removing dangerous criminals who have no right to be here. Hannity described the Alien Enemies Act as a powerful tool to ensure national security and viewed the appeals court's pause as a practical step needed to keep our communities safe from threats like Tren de Aragua, directly linking it to that specific group.
Okay. And the reaction from MSNBC?
Rachel Maddow on MSNBC, as reported by the legal team on June 11th, offered a scathing critique. She called the administration's use of a wartime law to deport people without hearings authoritarian and a grotesque abuse of power, arguing it bypasses fundamental legal rights. Mao stated these Venezuelans are being treated as pawns in a political game, not as human beings with rights entitled to due process. She argued the appeals court's pause undermines due process and sets a dangerous precedent for eroding civil liberties, potentially for anyone, not just immigrants.
The legal team's report also noted related stories tied to this event, connecting the dots.
Yes, the material connects this ruling to other recent court actions impacting immigrant status, specifically mentioning the Supreme Court's June 3rd ruling, which stripped legal status from some 500,000 individuals from Cuba, Haiti, Nicaragua, and Venezuela who were here on humanitarian parole or similar statuses. This underscores a broader trend of legal challenges impacting these specific nationalities. The legal team also notes that the nationwide protests over deportations, which we'll discuss next, are directly linked to actions like these summary removals. People see this happening and react.
That's a heavy topic indeed. Let's move to the third major event highlighted in the legal team's report. This one connects back to those protests we mentioned and directly involves that clash of federal and state power we saw playing out. This happened in California, specifically involving the National Guard.
Right. This event occurred on June 12, 2025 in California, and it represents a significant legal and political clash. High drama. The headline the legal team used was, "Appeals Court Shocks California Upholding Trump's National Guard Control." The summary they provided states that the Ninth U.S. Circuit Court of Appeals issued a ruling that paused a lower federal judge's order. This pause allowed President Trump to keep federal control over California National Guard troops that he had previously federalized and deployed in Los Angeles, specifically amidst the significant protests that erupted over recent ICE raids in the city.
Wait, so the president took control of state troops, a judge said he couldn't do that, and then a higher court temporarily reversed the judge. It sounds like a constitutional standoff.
That's precisely the situation described in the legal team's material. It was a very rapid sequence of events. President Trump had taken the step of federalizing a portion of the California National Guard troops, putting them under federal command instead of the states. The stated purpose was protecting federal buildings and assets during the LA protests sparked by ICE's aggressive actions. Then, on June 12th, U.S. District Judge Charles Breyer in San Francisco ruled this federalization and deployment was illegal. He found the situation in L.A. didn't meet the specific requirements of the Insurrection Act, the federal law the president claimed authority under. Judge Breyer ordered control of the troops returned immediately to California Governor Gavin Newsom.
Okay, so state control restored. For how long?
Not long at all. Later that same day, the Ninth U.S. Circuit Court of Appeals issued a swift pause on Judge Breyer's order. This pause effectively kept the National Guard troops under President Trump's federal command, at least temporarily. It put everything on hold pending a more substantive hearing on the legality of the original order, which was scheduled for June 17th.
What were the reactions to this rapid back and forth in the courts? Must have been intense.
Oh, yeah. The legal team's material highlights strong reactions from both sides. President Trump reportedly celebrated the appeals court's pause on his social media platform, Truth Social. He claimed the ruling had saved Los Angeles from burning to the ground, implying the federal troops were absolutely necessary to prevent widespread destruction. Governor Newsom, on the other hand, sharply criticized the federalization and the subsequent appeals court ruling. He called the deployment unconstitutional and dismissed it as political theater, not a genuine response to a situation state and local authorities couldn't handle. The material also underscores the scale of the federal response in LA, noting the involvement of about 700 U.S. Marines and around 4,000 National Guard troops brought under federal command. A significant presence.
What is the legal background here? What's the basis for a president federalizing state troops anyway? And what was Judge Breyer's argument that it was illegal in this specific case?
The legal team's background information delves into the legal basis. Presidents have limited authority to federalize state National Guard troops, primarily under the Insurrection Act of 1807. It's an old law. This act allows the president to call forth the militia, which includes the National Guard when not in federal service, to suppress insurrection, rebellion, or domestic violence if state authorities are unable or refuse to do so, or to enforce federal laws. However, the act typically requires a request from the state governor or legislature unless the violence obstructs federal law or operations or deprives citizens of constitutional rights to such an extent that state authorities can't or won't protect them.
So what did Judge Breyer find?
Judge Breyer's ruling, according to the material, found that the situation in Los Angeles, while involving civil unrest and protests, did not rise to the level of an insurrection or a complete breakdown of state authority that would allow the president to bypass the need for the governor's request under the act. And Governor Newsom had explicitly not requested federal troops. In fact, he asserted state and local authorities were capable of handling it. So the legal fight here really tests the boundaries of presidential power under the Insurrection Act versus the traditional authority of state governors over their own National Guard.
What are the potential implications of this legal battle and the appeals court's temporary ruling, according to the legal team's analysis?
The legal team's material points to significant implications across several areas. For immigrants and their advocates, the presence of federalized military-like troops on city streets during protests is seen as highly intimidating. This militarization could deter people from protesting and heighten fear in communities already targeted by ICA. For policymakers, both federal and state, this case could profoundly redefine the balance of power, specifically concerning the president's ability to deploy federal forces within states over the objections of local leadership. A ruling favoring federal control could be seen as a major expansion of executive power, and for communities experiencing this, using military forces to manage civil unrest, especially related to protests against federal actions, risks further escalating tensions. It could lead to more intense, maybe even violent clashes and deepen societal divisions.
The legal team provided key quotes and perspectives on this ruling as well. What stood out?
Yes, they did. Governor Gavin Newsom was quoted on June 12th, reiterating his position against the deployment. There is no invasion or rebellion in Los Angeles. There is civil unrest that state and local authorities can handle. Drawing a clear line, Defense Secretary Pete Hegseth, speaking from the administration's perspective on June 12th, defended the action, stating, "We're protecting federal interests, not defying the courts," implying the focus was federal property and operations. And providing analysis from outside the immediate conflict, Jake Tapper on CNN on June 13th framed the core issue succinctly. This is a constitutional showdown. Where's the line between federal and state power?
And the pundit reactions presented by the legal team on this National Guard ruling.
On Fox News, Laura Ingram, according to the legal team's June 12th notes, strongly supported President Trump's action and criticized Governor Newsom. She argued Newsom was obstructing federal efforts to secure our cities by resisting the deployment. She stated the National Guard was essential to restore order in LA, which she claimed was experiencing protests spiraling out of control. Ingram linked the need for federal intervention directly to sanctuary policies, claiming they turned cities into magnets for illegal activity, and argued Trump's action was exactly what's needed to protect law-abiding citizens.
Okay. And on MSNBC.
Ari Melber on MSNBC, as reported by the legal team on June 13th, viewed the federalization very differently. He called it a blatant power grab by the administration. He argued that using the military to quell protests over immigration raids is a dangerous escalation that threatens free speech and community safety. Melber asserted that LA doesn't need federal troops. It needs policies that respect its people, not militarized intimidation tactics that inflame tensions. He argued the deployment was more about intimidation and politics than real necessity.
The legal team also noted related stories for this event, tying it into the bigger picture.
They directly connected this event to the nationwide protests over ICE raids, highlighting that the federalization was a response to those protests, and then, in turn, became a point of contention within them, a real flashpoint. The material also mentioned President Trump's separate appeal to the Supreme Court concerning federal workforce cuts, suggesting a broader theme of the administration asserting and testing the limits of executive power across different areas.
That discussion of protests and the National Guard deployment leads us directly into the next major event. The legal team highlighted the widespread unrest itself, happening across the country.
That's right. The legal team's material emphasizes that the aggressive federal actions we've been discussing, the ICE raids, the military deployments, were major catalysts for a significant public reaction. The headline from their summary for the period of June 9th to 15th captures the mood. Nationwide fury ignites as protests rage against Trump's deportation blitz. They note that this past week saw significant protests erupt in multiple cities across the U.S., specifically against ICE raids and the administration's enforcement tactics leading to numerous arrests.
Where did these protests take place, according to the legal team's report? Was it just L.A. and New York?
The material indicates the unrest was definitely not confined to just those two. It spread across the country. Cities mentioned in the legal team's report include major hubs like Los Angeles and New York City, yes, but also other cities such as Seattle, Austin, Spokane, and Washington, D.C. The legal team specifically highlighted the scale of the arrests, noting that over 400 individuals were arrested in Los Angeles